Ed Cook. How
All
you doing,
right.
Judge?
I'm doing well. We're on the record of People's State of Michigan versus Edward Cook, file 210968FY. Counsel, identify yourself for the record.
I do so on behalf of the people.
Stephen Halsey on behalf of Mr. Cook for the limited purpose of his arraignment.
All right. Mr. Cook, Mr. Magistrate Ladwig had started going through some of the terms of your bond, and he was not able to complete those. So I just need to
You know what? Sorry, Judge. I was hoping he was there because I owe him a big apology for my motor mouth the other day. You know,
we all have those days, Mr. Cook. We all have those days.
You know, Judge, that bond went up so high. It was like, you know, there was no way I could get it. And it was just, I don't know, everything's kicking me in the hind end right now at home with the house. And, you know, I lost my house. Me and the wife were just closing on a new house we were buying. I've been staying in the camper with my two dogs because they can't go anywhere else. You know what I mean? Dogs are dogs. You can't just take them anywhere. But
you're right.
But I've had the one for 15 years, for God's sake. He's deaf and blind and whatever. I'd do anything for that guy. But, yeah. You know, I do, like I said, I owe that other judge apology because I got kind of mouthy with him. Just
all right.
I didn't mean to do that because, you know, I would stick up for the man if they come down to it, you know. Okay. And here's the thing, Judge. Can I say something? They said the other day that I didn't do nothing with that JA, but, you know, I got a hold of Becky Holmes. She's a very nice lady. Me and her talked. She gave me a phone number that took my insurance. And when I called them people up, I swear to God, the lady I talked to, when I took forever to get a hold of somebody, but when I finally did, she says, well, what are we supposed to do? And I said, I don't know. I assumed it was for a P test or something to get me started on something, but whatever. And she says, well, I don't know nothing about it. Well, I said, okay, well, let me get back. I'm going to go talk to Becky. And I went back to the jailhouse right here, and I talked to Becky again. And she said, you're kidding me. She said, well, I'll touch base with him. Now, I think I'm guilty because it was like I said, a couple of weeks, a week or two, and I didn't get a hold of Becky. I probably should have got a hold of her, but I really, really would like to get this thing back on. If we could do the PR bond again and get started with that JA, you know, and so I can get carried out with my life in the house and whatnot, you know.
Right. Well,
God,
let me take a shot. Hang on. Let me take a shot now so I have a chance to listen. So what we're going to do is we're going to put some bond terms in place. And if you're able to comply by them, I'll take a look at reducing the bond. But what we want to do is make sure that you're following up with pretrial services, that you test, you get a biopsychosocial assessment done, that you follow the recommendations, you meet with the pretrial services coordinator, Miss Becky Holmes. We'll do the urine test. You called it the P test. That's the same name, just different ways of saying it. And we're not going to have any, not going to use any drugs or alcohol or recreational marijuana. You're subject to random drug and alcohol testing. We want to make sure that you're involved in P511 programming if you are still in the jail. Right now, we have a higher bond. We want to get you an attorney appointed because Mr. Houseel is here just temporarily. So we're going to get you an attorney that's going to be longer term. The charge.
I thought Mr. Oh, I'm sorry.
That's all right.
Sorry.
So we're going to follow. Don't leave state of Michigan without permission of the court. Appear in court each time you're required. So we're just going to put those standard bond terms in place, and we're going to appoint an attorney for you. We already got our dates set in place, and so I'm going to take a look at it. If you're behaving yourself in the jail and following what they say to do and you stop your motor mouth, I'll take a look at that bond on a probable cause conference so that maybe we can get you back out. We want to get your head thinking clearly. We want you to be back on the straight and narrow. All right? Okay, good.
I do, like I said, I owe that other guy. What was that other judge? Who is he?
It's Magistrate Ladwig, but he just asked if I could just follow up and get stuff.
I know. I owe him a big apology. Like I said, I was a real that wasn't me. That was me, but I mean it wasn't me. You know, just
I understand. So as it stands right now, I think we got all the bond terms set in place. Mind your P's and Q's in the jail. We'll take a look at your bond again on the probable cause conference date. Want to make sure we got your head thinking clearly. Okay.
Good.
Thank you, Mr. Cook. Have a good day.
Thanks, Judge. Thanks, Judge.
All right.
Awesome. Am I good?
You're good.
Thanks, guys.
Hey, Chris. What's up?
Either one of you go ahead.
I went in yet. I want a day, right?
Good afternoon, sir.
Good afternoon. How you doing?
I'm well, thank you. Could you tell me your name, please?
Orlando Longs.
All right, Mr. Longs, I'm Judge Carpenter.
Okay.
We're going to call your case, and we're going to, I think you can take your mask down so we can chat.
Okay.
So we're on the record, the people state of Michigan versus Orlando Lamont Longs, file 21-0973 SM. Counsel, identify yourselves for the record.
I do so on behalf of the people.
Orlando Longs.
Thank you.
In-house on behalf of Mr. Longs for the limited purpose of his arraignment.
Okay. Mr. Longs, Mr. Houseel is limited. It just means that his job today is to talk you through this process. If you want to have a lawyer after today, you have to do one of two things. You either have to hire one or request a court-appointed attorney. We're going to talk about that in a minute. So what's going to happen is now, I'm certain Mr. Houseel has done his regular good work. He's told you how to understand what the process is. So I'm going to read you the charge. And then all I'm going to do is ask if you understand the charge. I'm not asking you to agree with it. I'm just asking if you understand it.
Okay.
And then I'll ask Mr. Houseel what he thinks you should do. I think he'll probably either stand you mute or plead stand you mute or plead not guilty. Then we're going to talk about a lawyer. Then we're going to talk about bond. Okay?
Okay, thank you.
Yes, sir. So I'm going to show you on this computer screen, and Ms. Dusso is here for the people. Mr. Houseel is for the defendant. I'm going to show you on the computer screen a copy of the document. If you would let me know when it appears on your computer screen, I'll tell you when you should expect it. It should be there right about now.
Yes, it's here.
All right. It might be hard to read, but I just want you to see where I'm getting the information from. So the allegations stem from an incident that allegedly took place on July 11th at an address at 806 Norwich Street, which is in the city and county of Midland. The allegations by the prosecutor are that you made an assault or assault and battery upon a Rachel Anderson, an individual with whom you've had a child in common, or a resident or former resident of your household, or your spouse. Typically, if you were just charged with the first offense, it's a misdemeanor up to 93 days. But because they're alleging that you had had a prior conviction on March 18th, 2019 in Genesee County, this makes it a second offense. That is a misdemeanor punishable by a maximum penalty of up to a year in jail and or $1,000 in fines plus court costs. Now, it does say something about consecutive sentencings, but there's not a second charge. So that won't apply here. So do you understand you're charged with domestic violence second offense and that the maximum penalty is up to a year and the fine maximum is up to $1,000?
Yes.
All right. Mr. Houseel, how do you advise your client to plead to the charge?
Mr. Longs enters a plea of not guilty and requests a court-appointed attorney.
Okay. All right. So, Mr. Long, we're going to now talk about your finances. We need to do that just because I see if you qualify. So, let's see. And it is Longs with plural S, right?
Yes, sir.
Okay. So, I'll enter a not guilty plea. Teresa, do we have the next date for Mr. Longs?
That would be July 27th at 9 a.m. if you appoint an attorney.
Okay. July 27th at 9 a.m. And I need to go over your financial situation because you have to qualify for our assistance. So let me see calendar. Bear with me just a minute. There we go. There's a lot of clicks to get it up and running first time, so I got it up and running now. So I'm going to show you a copy of the document so you can know where I'm getting my information from or where the form that we're looking to fill out. Remember, this is only about your finances to determine if you qualify. So the address that I have for you says 806 Norwich Street, and we may have to talk about you being able to go back there because I'm going to be a no contact order for a while, but let's presume that that's not the case. This is typically where you live. Is that true?
No.
You don't live at 806 Norwich. Where do you live?
1918 Woodsley Drive.
Goose Lake?
Woodsley.
Oh, Woodsley.
WOODSLEA.
Oh, I wouldn't have got that. All right. So where's that at? What town?
Burton, Flint, Genesee,
Okay. You know the zip code there?
48507.
All right. 507. Okay. Is that a place you rent, you buy, or you live with somebody else who rents or is buying it?
Me and my cousin share the apartment.
Okay. Do you pay? So remember, the purpose of this is trying to determine how much money you might have. So do you pay rent with your cousin, or you said you share
Yes,
the
sir.
apartment? How much do you?
Yes,
how much
sir.
is your share?
About 400.
Okay, so you pay 400. Now, this gets into how many people you may have to support on your income. So, are you single, married, divorced, or separated?
Separated.
Okay, and do you have any minor children, meaning children that you have to pay support for?
No.
Okay. Are you currently employed?
No.
When you do work, what do you do?
I'm not unemployed. I'm disabled.
Oh, you're disabled. All right. Do you receive
Yes,
disability benefits?
Yes, sir. Disability. Yes, the first and the third.
Do you receive any veterans benefits? Were you part of the military, or just a disability from Social Security?
Just through Social Security.
All right, I'm going to go ahead and appoint an attorney then to represent you. So you'll have an attorney the next time. So the next date on July 27th, you won't have to do anything. However, you'll have to be in contact with your lawyer. So your lawyer's going to talk on the Zoom and see if there's an offer. If you can reach an agreement,
Okay.
then you'll do a plea. If you can't reach an agreement, we'll set it for trial. But they're going to need to be able to get in contact by phone. Do you have a telephone number that we can give to them?
Yes, sir.
Okay, what is that, sir?
810
Sir?
525 3996.
And if we ended up needed to talk with you like this, video, do you have the capability with your phone to be able to do video conferencing?
Yes, sir. I have an iPhone.
Okay, good. Do you have an email address then? So if we need to send you some information so that you can know how to log. Could I have that, please?
Yes. ORLNDLNGS27@gmail.com.
Thank you. Okay, so now let me ask Mr. Houseel a few questions then. Mr. Houseel, your argument regarding bond, sir.
You know, I have limited information here on this incident. I think Mr. Longs does have some record background. I think perhaps his most recent incident, other than the one that was just cited of 2019, was probably about 3 years ago, maybe just slightly longer than that. And apparently my understanding is that at the time, don't know who notified the police, but at the time they arrived, he also had someone there who was taking him from the residence, which is the address is where his wife that he separated from lives. And also my understanding is that no one was injured or harmed during the incident. And in fact, it had largely been over by the time the officers arrived. Also, I don't believe that Mr. Longs has had any problem of being in court when he's supposed to be in court. I don't think he presents a danger to the community here in Midland, especially with his residence being in Flint in Genesee County, where he intends to go. So I just ask that the court take that into consideration when determining bond. Thank you.
Okay. Ms. Dussault, comment regarding bond?
Yes, Your Honor. As to the incident itself, the victim was in fact injured. Mr. Longs pushed her into a window that broke. She's got some cuts. There's some blood on her arm and her shirt. So there was an injury involved. I believe it was her son that had to pull Mr. Orlando off of her. So again, other people involved. But so there obviously was a little more going on, I think. We would ask that he not have any contact with the victim. and that he be placed on pretrial services. According to the report, he appeared to be intoxicated and was in fact drinking a twisted tea while he spoke with the officers. So I think there's reason to additionally make sure that he's not having any alcohol or drugs while he's on bond.
All right, thank you.
Additionally, I would draw some attention to his history. It spans quite a time, but it is all assaultive in nature, including some out-of-state history. And frankly, the only reason this isn't charged as a felony is because we want to make sure that we can actually get those records from Tennessee. It appears that his most recent case involved a felon in possession of a firearm along with domestic violence in 2019. And then prior to that in 2009, and then that was one of the Tennessee charges. I think in 2002 or 2003 was the other one. In between there was a resisting arrest. 1996, there was an assault, intention to great bodily harm. So there is reason to believe that he would be at risk.
Can I speak?
You can, but it's I don't know if your lawyer wants you to or not. So you're free to, but remember you're being recorded, so anything you say could be later on.
That's fine. All them charges that she named off, I was a kid. I was young. I wasn't fully mature. I have caught a case in like 3 years ago, but like I said, I've been doing good. I've been staying out the way. I don't get in trouble. Don't do drugs. I have a drink every now and then at the house, but other than that, I really have been doing pretty good. I can say for myself, staying out the trouble, staying out the way. Now, if a person get mad at me and call the police on me, I have no control of that.
Okay.
But as far as me going get myself in trouble or anything like that, I do not. I've been a good abiding citizen for these last few years and more than a few years.
Okay. Well, I appreciate that. I am looking at criminal history, the same one that Ms. Dusso was. The one question I do have is because the most recent one was from Tennessee in 2019. Are you on probation or parole anywhere, or are you all done with that?
No, I don't have any probation, no parole, nothing. In 2019, I wasn't in Tennessee.
That was from Genesee County.
Oh, Genesee. I'm sorry. There's a Genesee and
no,
a Tennessee.
There are priors from Tennessee. He also was in Genesee.
That's what I was talking about.
Yeah, that's all right. So
back then I was.
Yeah, I'm certain we have all had circumstances that we wish we could go back and talk to the younger person.
Yes.
Yes. Pretty directly if we had a time machine.
Yes.
So the only reason we do that, I'm going through those, even though I recognize you could be a different person then as what you are now. We all hopefully grow and change, is that I'm required to go through certain things in my court rules. So when I'm kind of taking a look at this, there's two things I take a look at. One is I got to make sure the community's safe, and the other one is make sure you show up to court. There is some Secretary of State stuff that maybe you didn't show up for some traffic things, but for the most part, I don't see there's any bench warrants for you. So it tells me that most of the time it would appear that you show up to court. However, now I'm just going through Court Rule 6106 F1. So it does show when you were younger in the 1996 conviction out of Genesee County, which was in Michigan, that you went to prison for. And then in 2002, there was a pretty big gap. There was domestic violence in Tennessee, and in 2005, an open intox in Genesee, which is in Michigan. And in 2008, there's a resist, stop, frisk, halt, arrest out of Tennessee, which is a misdemeanor. A 2009 assault, domestic fear of bodily injury in Tennessee. A 2013 impaired driving in Burton, that's where you're living now. And a 2019 felony firearm in a DV with habitual second out of Genesee County. So it's been a few years. However, most serious ones probably. Yep. So that's right. So those are things that I have to take into consideration. The fact that you were intoxicated in this offense. So if I'm going to let you out on bond, I just need to make sure that we put you in the best position so that you're not causing trouble. So I'm going to let you out of jail without having to pay money, but you're not able to have contact with the victim. So no contact. That means direct or even email or Snapchat, Facebook, anything.
Well,
okay.
You have my address, you got my phone number, and I'm not a runner. You can see that. I walked my probation down, I walked my parole down. I never got in trouble on none of them.
But this night,
like I said,
you're still innocent until proven guilty on this charge, but you were drinking, so I'm going to order no alcohol. I'm going to order some testing.
Okay.
So what we're going to do is put you on pretrial services. I'll have my probation staff. You're still innocent, but I got a staff that will contact you to get some counseling set up. You just need to. They'll contact you by phone to make sure that you get everything set in place, and that you're interacting with some folks down there, and that no aggressive, abusive. So if you get into an argument or fight, most people don't go to jail for that, but you might because I'm ordering you not to do that. Do you understand?
Okay. I just for the record, we've been here a little over 3 years in Midland.
Yes.
Well, my wife and the kids and stuff. I've been a law-abiding citizen. I help with the community. I mean, you can ask my neighbors and stuff. I grow vegetables. I give them vegetables and stuff, lettuce and everything. I don't be into that type of stuff.
Right. So I'm not doubting that, sir, at all. I just need to make sure we got some separation between you and your wife. So you're going to be. I don't want any contact now till we can figure this out. So if you go down to the Burton place and live with your cousin, don't have any contact in the interim, so we can make sure that it's a good risk. And then you will be in contact. Your attorney will be in contact with you by your telephone number. So there's nothing you need to do on July 27th. But my staff's going to call, so you'll get they won't talk to you about the event, but they will talk to you about if you're getting your testing done. And no alcohol, no recreational marijuana, no illegal drugs. We don't want you on any of that stuff. It doesn't help clear thinking anyway. So no contact with them. You already can't own a firearm because of your prior conviction, so I don't contact that. Anything else, Ms. Dusso, you'd like to have on the record in the bond?
We addressed the drugs and alcohol, right?
Yes.
Okay. That was
all right, Mr. Halseal, anything more?
Nothing further.
All right, so all you got to do, Mr. Longs, is do what you say you've been doing. Be a law-abiding citizen. Don't have contact with your spouse right now. It doesn't mean it forever. And no drugs or alcohol.
It's reasonable.
Okay. All right.
Do I get a bond?
Yeah. No, I'm not
getting a bond.
It's a PR bond, so it means you don't have to pay any money. Once they process you, you can get out of jail.
Okay. Thank you.
Thank you. We'll be adjourned.
Y'all have a blessed. Y'all have a good week.
So we got one more person we need to address. Yep. Good afternoon, sir.
Good afternoon.
Could you tell me your name, please?
Zachary Riggs.
Just one moment. Charles, did you get an opportunity to look at the amended complaint? There was an amended complaint filed in this case.
The information that I have is simply 4 counts. Counts 1 through 3 are R&O and account 4 OWI, and that's all the information that I have.
Okay, so they had the prosecutor had added a habitual offender notification to the case. So I'm going to go ahead and officially call the case. That was signed about 2 o'clock, so I didn't know if you had an opportunity to see that or not. So we're on the record of People State of Michigan versus Zachary Lee Riggs, file 21-0972FY. Counsel, please identify yourselves for the record.
I do so on behalf of the people.
Stephen Halseal on behalf of Mr. Riggs for the limited purpose of his arraignment.
All right, Mr. Riggs. Mr. Halseal means limited purpose because his job is to get you through this arraignment. And so if you wish to have a lawyer after today's date, you have to hire one or request a court-appointed attorney. So I'm going to follow the process that Mr. Halseal had told you about. And I'm going to read you some charges that have been filed against you. And then I'm going to ask if you understand the charges and the maximum penalty only. I'm not going to ask you how you plead. Mr. Halseal will plead on your behalf. So let me pull up. There we go. I'm going to show on the computer screen a copy of the document. Teresa?
Yes, Judge?
I don't have the most recent one. Can we see if it can get scanned in and submitted or by sent us by email?
Sure.
Deputy Stanka swore it out, and that's the reason why I wanted Val to know about that so we could update the file, but it did not get done.
Do you want me to screen share it so you can read it, or?
Do you have the most recent one from the signature one?
I've got one from 7/10/21. Appears. Oh, you know what? I don't know if this has the HAB on it.
Yeah, the 12th. They added habitual to it. That's the issue, and I just signed it a few minutes ago.
Your Honor,
Yes.
I'm sorry. I'm sorry to interrupt. I did talk to Val. That is the very. She did scan it. It should be with the originals.
Should be with the originals.
Well, I can't have another felony.
There it is. Okay. All right. So, sir, let me go ahead and share this document with you. Should pop up on the computer screen at any moment. Can you see it on the computer screen?
Yes, sir.
All right. Prosecutor has charged you. I'm going to slide down to the second page of the document. They have charged you with an habitual offender fourth because some of these are felonies. I'm going to read you the habitual offender because it has an impact on the upper level charges. So in this case, sir, prosecutors charge you as habitual offender because on June 7th, 2010, you were convicted in Clare County of breaking and entering a building with intent. On May 9th, 2011, of breaking and entering a building with intent in Clare County. On May 25th, 2012, receiving and concealing stolen property in Common Pleas Court for Montgomery, Ohio. On May 25th, 2012, carrying a concealed weapon in Ohio. July 10th, 2015, of larceny in a motor vehicle in Isabella County. So this would be at least your fourth felony because there are some felonies here, and it has a multiplier effect. If the felonies are the lower ones, so here, sir, you're charged by the prosecuting attorney's office with four crimes. 3 resisting or obstruct police officers and 1 operating while intoxicated. It is alleged that on or about July 9th, you're operating a motor vehicle on South Meridian Road, Homer Township, Midland County, Michigan. And in count 4, they're alleging that when you were on East Miller Road, you were under the influence of alcoholic liquor, and that is a misdemeanor punishable by up to 93 days in jail, a fine between $100 and $500, and or 360 hours community service. Rehabilitative programs could be ordered. Vehicle immobilization may be mandatory depending on your driving history. You may have to pay the cost of prosecuting you, reimburse the government for any emergency response equipment that were called there. And then when they were effectuating the stop, you're charged with 3 counts of resisting obstructing a police officer. In count 1, it is Deputy Levely. It is alleged in the same date, time, and place you did assault, batter, wound, resist, oppose, or endanger Deputy Levely as sheriff or deputy sheriff of the county of Midland. Typically, that's a felony punishable by up to 2 years in prison and or $2,000 in fines plus court costs. Consecutive sentencing may be imposed if it took place in a place of confinement. For you, it could be up to 15 years with the habitual offender fourth. In count 2, you're charged with resisting Deputy Smith because it's alleged you did assault, batter, wound, resist, oppose, or endanger Deputy Smith. Again, typically up to 2 years. For you, it could be up to 15 years in prison and or $2,000 in fines. Potentially, it is consecutive. Finally, you're also charged with resist, obstruct Lieutenant Sutherland because it's alleged in the same date, time, and place you did assault, batter, wound, resist, oppose, obstruct, and endanger Lieutenant Sutherland, deputy with that's up to 2 years in prison, $2,000 in fines plus court costs. For you, it could be up to 15 years in prison, potential consecutive. So 3 counts resist, obstruct, 1 count of operating while intoxicated, and habitual of fourth. Do you understand the charges? I'm not asking if you agree with them. Do you understand what I've just read?
I do understand what you just read, yes, sir.
All right, Mr. Halseal, how do you plead your client?
Mr. Riggs enters a plea of not guilty and requests a court-appointed attorney.
All right. Mr. Riggs, now I'm going to determine what the bond will be. We'll need to set a probable cause conference. Teresa, do we have a probable cause conference date and a preliminary examination date?
Probable cause, July 27th at 1 o'clock, and the preliminary exam, August 3rd at 2:15.
Okay. All right. Sir, you're planning on requesting a court-appointed attorney. Do you still live at 7345 Loomis in Coleman, Michigan?
No, sir.
Where do you live?
5520 Bard Road, Beaverton, Michigan.
What's the zip code there?
48612.
Who do you live there with?
My mom and my brother.
Is it mom's place and you're living with her?
Yes, sir.
Does she charge you any rent?
No, but I help out. I just started working again. I'm the only one that provides for me and my kid. His mom don't work because she stays home.
So you have one child?
Yes, sir. His birthday's in a week and I was hoping to be out.
Single, married, divorced, or separated?
If you would go by that, single, but me and the mother are together, but we're not married.
Do you all live with your mom?
No, she lives in Irons with her mom because our house is too small and where she's at's too small for all of us to be in one spot.
Okay. And where is it you work?
I work here in Midland. I roof. I just started that and I was supposed to get my first check Saturday.
Who do you work for?
His name's Kevin Harris.
So Harris Builders?
Yeah, I'm guessing that's what it's called. I don't know the actual name of it.
All right, I'm going to go ahead and appoint an attorney for you. Mr. Halstead, your argument regarding bond.
At this point, Your Honor, I think it would likely be highly inappropriate for me to try to address bond. There's obviously a lot going on here, just based on what I see in the charges, much less anything else or what I have or have not been able to learn, but had no opportunity to see a police report or to obtain any other kind of information on the background here. So at this point, I have too limited information to make a reasonable argument for bond. Perhaps if Ms. Dusso provides some information on the basis for their charges, that would be helpful.
Ms. Dusso.
Your Honor, it appears, at least from what I can see, that as far as criminal history, there's larceny from a motor vehicle in 2015, carrying a concealed weapon out of Ohio from 2012, along with receiving stolen property out of Ohio in 2012, and then 2 B&Es with intent from 2010, 2011. So largely theft crimes, but I do see obviously here that we've got an OWI, so I don't know if any of that is motivated by a substance abuse issue. But I think that, there's obviously something going on with Mr. Riggs. It's driving some of this behavior. Given the 3 counts of R&O, there is some amount of risk here. He had some pretty nasty behavior, I think, toward the officers and just the language that he was using and the things that he was doing in the patrol car. So I don't know, there may be mental health concerns too. I certainly think that he needs to participate with pretrial services, try to get some of this figured out. Obviously ask that he not have any alcohol or drugs. He's on bond, but maybe an assessment would be in order before he's released.
Okay. Mr. Riggs, you had your hand in the air. Did you have a question or did you want to say something?
Yes, I did, sir. Thank you. That night, I don't never act like that. I'm never aggressive. If I'm getting arrested, I'll put my hands behind my back so that way it's easy for them. I think I had a mental breakdown because I was getting taken away from my kid because I'm the only one providing for him. He's autistic. He's going to start this ABS school speech thing because he don't talk yet. And I just wanted to be there when he first started talking. His birthday's in a week. And it all just, I don't know, it all came together at once. And when I was actually being arrested, because I didn't know my hands were being forced off the steering wheel.
Hang on. You're getting really close to admitting facts that could convict you. So I'm going to stop you. So if a police officer tells you to do something and you don't, then that's enough to meet the crime. So I don't want you to put in a position to where you're a defense attorney who appointed to your case. Hang on. This is for your own good. So you're being recorded. So I don't want you speaking. All right.
Yes, sir.
I set an initial bond at $100,000 cash or surety. I was concerned about the defendant. I was the magistrate that reviewed the facts. He was acting in a bizarre, strange fashion for that evening. I didn't know whether it was him or the alcohol or some mental breakdown, as he states. So I have to take that into consideration. He's not been convicted of a crime since 2015. Or he has 6 prior convictions. Ms. Dusso is correct. They're all larceny based. He has had some bench warrants for failing to appear for a retail fraud charge down in Saline, Michigan. So he has some circumstance where he's not appeared in court. So
that was not me.
You know,
Saline, Michigan.
Saline, Michigan. They have an old case that you need to get cleared up. So
I've never been to Saline, Michigan.
Well, you may not recognize it as that. It may need to be near Ann Arbor, or it could be some places close. That's just where the courthouse is. So it is going to be the bond in this case that the defendant may not leave the state of Michigan without permission of the court, must appear in court each time he's required, may not consume any alcoholic beverages, illegal drugs, or recreational marijuana.
I'm fine with that. I am fine with that.
Yeah, it's my turn to speak now, though. He's to have random drug and alcohol testing. He's to get biopsychosocial assessment done at J&A Counseling Services, follow all the recommendations, and meet with the counselor, and meet with Miss Rebecca Holmes or the pretrial services coordinator at least 2 times per month, or as she deems appropriate. He, in this case, because of some concerns, I do want to have him involved in some type of testing, as well as counseling. If he's unable to make the bond, then I'm setting he is to engage in the PA 511 men's cognitive behavioral group. And if he does make the bond, then obviously he's to engage in the pretrial services and services that are ordered. I'll reduce the bond from $100,000 cash or surety. You do want him to have a mental health assessment done if it's deemed necessary, but I am going to set it at $25,000 cash or surety bond. In this case, I may review it again on July 27th. But I do believe that some cash bond is necessary. We'll be adjourned on this case until July 27th at 1 o'clock. Preliminary examination will be taken on August 3rd at 2:15. I am ordering a court-appointed attorney. We'll be adjourned on this case. Thank you.
Your Honor, we have an Alicia Vaughn in the waiting room. I think she had a set-aside hearing set for today, but I don't believe we got any paperwork from the Attorney General, so it was taken off the docket.
She did right. She didn't even file a motion.
Do you want me to bring her in and so you can talk to her? Okay.
Do you need me for anything on that, Judge?
No, I think we're all set for that one. We do have a motion for someone to get out of the case at 3:30.
Is it one of Patrick? I think he was talking about that.
Okay. Ms. Vaughn?
Yes.
You had scheduled this time for set aside conviction, but you have to file a motion. You have to file the paperwork. You didn't file any paperwork.
I sent in all my envelopes and my money I went up to the courthouse and she gave me a paper to fill out to send all my stuff out.
It has to be checked out by the Attorney General, and it has to be followed up by the prosecuting attorney, and there actually has to be some documents filed. So I can't tell you how to do it, but I've got no motion to review. So we'll set this for a different time, but I don't have paperwork in order to make this happen. So you may want to follow up with my staff.
Okay.
Okay.
All right.
All right.
Thank you.
All right. We're off till 3:30.